This is the quorum, as they say, 7 of them. On the issue of jurisdiction, this is how it goes. The majority opinion. This is Adom-Otchere speaking. He says, but more important is the need to emphasize that the dispute in issue arises solely from what the proper interpretation and application of Article 97(1)(9)(h) is to the fate of the affected MPs filing nominations to contest the next elections as independent or on tickets of political parties that they do not currently represent. The suit essentially hinges on a pure question of law, specifically the proper construction of Article 97(1)(g) and (h) to establish the legal threshold for triggering its provision, without delving into the factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. Accordingly, to the extent that the exclusive preserve to settle a matter. Okay, let's try and understand what the judge is saying. So he's saying that the whole issue hinges on Article 97. At which point do you trigger the process? At which point do you trigger the process? And then he's recognizing that Article 99 directs that this matter about whether a seat is vacant or not is truly the preserve of the High Court. He recognizes that. Then he continues by saying that to the extent that the exclusive preserve to settle a matter of interpretation under Article 2.1 and Article 130 and 130(1) and 2 lies within the Supreme Court, it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court. I think that's very erudite, very, very interesting. So he's saying that he's making the argument very, very strongly. And the argument here is it the High Court's decision to make or is the Supreme Court's decision to make in terms of whether a seat is vacant or not? Now, everyone recognizes, and it's very straightforward language in Article 99, that the High Court has been given jurisdiction to declare whether a seat is vacant or not. It's been given an exclusive jurisdiction to declare whether a seat is vacant or not. The issue here is, does the processes in Article 97 have those processes in Article 97 accrued right now? And that is a matter of interpretation. And that's what he's saying here, that when it comes to the matter of interpretation, the Supreme Court have the preserve in Article 2.1 and 130(1) and 2 to deliver it. So High Court has power to declare whether a seat has become vacant or not. The case of if you file nomination at the Supreme Court, at the Electoral Commission, to contest the elections on the ticket of a different party in the next election, have you offended Article 97, which therefore requires that your seat is vacant? This is the matter of interpretation according to Justice Adom-Otchere. And he says that is why the Supreme Court has exclusive jurisdiction over this matter. That was his talk on jurisdiction. Let's see what the minority opinion is. The minority opinion, one of them carried by Lovelace Johnson, is as follows. She says, the fact that this court is clothed with exclusive jurisdiction under Article 130 of the Constitution, subject to that given the High Court under Article 33, to deal with all matters relating to the enforcement and interpretation of the Constitution and any allegation that an enactment was made in excess of the powers of Parliament or any authority or person by law or under the Constitution, which jurisdiction in any case can be exercised upon a reference from the High Court in appropriate circumstances. Okay, the bracket is confusing the reading, so let me start again. The fact that this court is clothed with exclusive jurisdiction under Article 130 of the Constitution to deal with all matters relating to the enforcement and interpretation of the Constitution and any other allegations that an enactment was made in excess of powers of Parliament or any authority or person by law under this Constitution does not mean that the clear provisions of Article 99, which provides the forum for hearing and determining the core issues in this matter, can be ignored. Okay, so she is saying that the fact that the Supreme Court has exclusive jurisdiction to deal with matters of interpretation of all kinds and enforcement of the Constitution of all kinds, it doesn't mean that the provisions in Article 99, which says that the High Court shall have power to declare whether a seat is vacant, that provision should be undermined. She continues. She says, I am satisfied that the High Court being the proper forum for this matter but the plaintiff having filed his writ in the Supreme Court, the jurisdiction of this court has not been properly invoked. I therefore see no need to go into the merits or otherwise of the other issues raised in the memorandum of issues. The action is accordingly dismissed. That's Justice Lovelace Johnson. She dismisses the action on the basis that the forum is wrong and that the forum ought to be the High Court. And here she says that the High Court have exclusive jurisdiction. Justice Darko says that the Supreme Court must give the interpretation of 97 to guide the High Court when it's about to declare a seat vacant or not. Now, those who support the majority opinion are saying that the problem with the minority opinion could be that they're saying that the problem of the minority opinion is the same problem that gives us a culture of delaying cases. And they're saying that if the minority opinion were to win, it will mean that the plaintiff must first go. They've come to the Supreme Court already. They stop the Supreme Court, go to High Court. High Court will rule. They will adjourn. Somebody will come in and say that let's go back to the Supreme Court for an interpretation of something indirectly related. They will go back to the Supreme Court, come back to the High Court. That's what will happen. And this is why cases delay. That the minority opinion may be that kind of expression that sometimes can delay cases. That's what those who support the majority opinion are saying, that the majority is clearly right. This is a matter of constitutional interpretation. Interpret the Constitution, let's move on. When you interpret the Constitution at the Supreme Court, it affects every other matter below.